good to go as you're good. Good morning. My name is Anna Keller. I'm the Executive Director for Maine Citizens for Clean Elections. And a few minutes ago, we filed suit in Kennebec County Superior Court. We asked the court to order Governor LePage to release the Clean Elections funds that candidates have qualified for. Elections are the most basic and fundamental element of democracy. Faithful implementation and administration of election laws is essential if citizens are to have faith that their participation matters. Nothing could be more important to the success of our self-governance. Maine voters have repeatedly affirmed their desire to have a robust clean election system as part of our election laws. Offering qualified candidates limited public funding in exchange for giving up private campaign donations helps keep lawmakers accountable to voters rather than donors, and it provides opportunity for a broad array of Maine people from all walks of life and across the political spectrum, to run credible, viable campaigns for state office. This in turn provides Maine voters with choices at the polls and resources for vigorous First Amendment activity right when it's most needed during an election. Legislative attempts to repeal, weaken, and defund the law over the last several years have been unsuccessful. Opponents have tried and failed to undermine the law on many occasions, but have simply not prevailed. Today we have a strong clean elections law, strong participation, and adequate funding in place, and we are well into the election cycle. But opponents are not willing to live with the express will of the electorate and the legislative branch. Over the last months and weeks, their efforts have turned to blocking routine administrative channels in order to undermine both the clean election system and the 2018 election cycle. Maine Citizens for Clean Elections today stands in support of faithful and full implementation of Maine's election and campaign finance laws, and asks the court to correct the actions of the governor and others who aim to disrupt the election cycle. We seek relief so that Maine candidates and voters will enjoy free and fair elections, including robust public dialogue and freedom from special interest dollars. Now I want to introduce John Brodigan, the attorney who's brought this case on behalf of candidates using clean elections and citizens who make qualifying contributions.
Thank you, Anna. Just want to clarify for the record, just because of the rain and the weather, we haven't actually filed it yet. We're going to do it right after the conclusion of this press conference. I'm going to kind of depart from my comments a little bit, but I'm just going to say we don't take an action like this lightly. It's been a long course of events that got us to this point where we feel like it's time for the court to intervene. This is not about personalities, it's not about politics, it's not about partisanship, it's about the rule of law and applying the will of the voters in a common sense way to the situation that's before us. If you follow this lawsuit in the days ahead, I think you're going to hear a lot of words like allocations, encumbrances, allotments, fiscal orders, fiscal years, budgetary mandates. That's all fine. We'll sort all that out, but that's not what this lawsuit is about. In 1996, the people of the state of Maine took it into their own hands to define the funding system that's going to be available for candidates with elections. At that time, and it was reaffirmed in 2015, at that time, the citizens, through acting at the polls, through citizen initiative, established the Ethics Commission as a new, strong, independent state agency. They endowed it with the authority to administer the fund. They created the fund. They identified and committed to several funding sources to go into the fund. The legislature has now filled the fund with funds. There's over $5 million sitting in it as we're here today. What more do we have to do? Candidates relying on this program over the last year have signed up and made substantial sacrifices and commitments to participate in the program in reliance on the funding that was duly appropriated and placed in the fund and authorized under law. The Ethics Commission provided all the guidance in the world to allow candidates to expect that the money would be there for them as promised and as committed. Those candidates were backed up by 45,000 individual citizens who provided qualifying contributions in support of their candidates. Everything is in place except one thing. We need a signature on a financial order to release the funds that are legally authorized the Ethics Commission to use for the purposes for which they've already been committed. When you hear an agency say things like broken promises and unfair to candidates, you know we have a serious problem. We are at a loss for how to solve this problem without asking the court to intervene. That's why we're here today. We hope for a quick resolution. We hope for a solution that will honor the will of the voters. And we hope that we can resume this campaign cycle as it was intended and as it's been conducted for the last 18 years, with full allocation of clean election funding available to candidates as promised. You want to take questions or you want to?
I'd like to introduce Senator Ben Shipman, one of the plaintiffs on the lawsuit.
Thank you, Anna. Hello, everyone. I'm State Senator Ben Shipman. I'm running for re-election. I'm also a clean elections candidate. And I am here for 3 reasons. I'm a plaintiff in this lawsuit for 3 reasons. First of all, I think it's critical that we uphold and support the will of Maine voters who have voted to support, establish, and strengthen clean elections in 2015 and also back in 1996. I worked on both of those campaigns. Secondly, I think it's important that we honor our commitment to candidates and that we do not change the rules in the middle of the game. Candidates who have qualified for this funding, and also to the thousands of Maine residents who have helped them qualify by donating $5 and signing the qualifying contributor forms. And third, we cannot allow one person, the governor, to unilaterally block funding that's already been approved for this purpose. This is not about partisan gridlock in Augusta. This lawsuit is about one thing. It's about the governor not signing off on a financial order and blocking funding that's already been allocated for this purpose. It's been allocated in statute, it's been budgeted, it's been agreed upon by myself and my colleagues on both sides of the aisle, from the House and the Senate. And we cannot allow the governor to get away with blocking this funding, and that is what this lawsuit is about, and I'm optimistic that we will prevail. Thank you.
Thank you, Senator. Now I'd like to introduce Crystal Canny, independent candidate for State Senate District 27. Good morning. My name is Crystal Canny, and I'm running as an independent for Senate District 27 in Portland. I am also a clean elections candidate. I had the privilege of working on clean elections 8 years ago, never thinking I would be using it on my own campaign, but boy, am I glad it was there. We're here today to reinforce what the people have said they wanted and the legislature has approved. Voters want elections that allow people to run free campaigns, free of money from lobbyists and big money donors. The only people elected leaders should be beholden to are the voters. Clean elections is critical to this process. Whether you agree or disagree with clean elections, I hope you take this as an important takeaway. You are watching the rules get changed in the middle of the process. If there are issues with clean elections, which I don't think there are, we should finish this election cycle and address them. This is politics at its worst, and there has been plenty of that during this last legislative session. How about we just put the people first? The decision to refuse to distribute clean elections money that is sitting there has nothing to do with what the people have said they wanted. And finally, this isn't and shouldn't be a partisan issue, but politicians are eager to make it one. This isn't about being a Democrat, a Republican, or an independent. This is about keeping money interests out of the system. The people want it, the legislature approved it, and now it needs to happen. And we are happy to take questions.
I assume we'll get like a copy of the lawsuit here, but are you the only 2 plaintiffs, and what are you sort of, so there are 2 issues right now, obviously the financial order issue and the authority that you're trying to provide first. Are you looking to remedy both those issues? That's a compound question.
John, what did you say about
Those questions are interrelated to some degree, but right now we're talking about fiscal year 2018, which ends in a few days. And the immediate question is the release of funding for candidates who have already qualified, already been promised that funding. Yesterday, there was a proceeding at the Ethics Commission, and candidates are going to get an 80% reduction in what they qualify for under the statute. It makes no sense. The money's in the fund. The candidates have done their part. The Ethics Commission has done its part in requesting the release of the funding. The citizens have done their part in supporting their candidates. Everything's been done. So for this fiscal year, all of the pieces are in place except the release of the funding. There's just the one piece that's left. Now, there is this question that starts in the next fiscal year with the errors bill. And it is, the legislature is still in session. And in their wisdom, the legislature could address this in some way, shape, or form that I can't anticipate right now. It's still a live issue. So I wouldn't preclude the possibility that something that the legislature does when they come back on July 9th would have an impact on this litigation. But right now we're asking for relief for this fiscal year.
Would there be a lawsuit? Do you anticipate a lawsuit at the status quo? Another lawsuit at the status quo stays, the status quo kind of continues.
I would say that the same legal principles and the same factual predicate that I just explained, the commitment to the state obligates the fund in the exact same way, regardless of the technicalities at the end of one fiscal year and the beginning of another, where the commission has the statutory authority to administer the fund. The fund is defined in law as a special, dedicated, non-lapsing fund. Those words mean something. That means the Ethics Commission controls the fund. All of the legislative authority is already present for the Ethics Commission to release that funding. Just need the person who writes the check to release the funds. That's
The commission doesn't agree with you on that.
With fiscal year 2018 ending tomorrow, are you asking the court anything specifically regarding that?
We are asking for relief within, we're asking for 10 days, a hearing within 10 days. We're not asking for anything by tomorrow.
Is the focus of the suit, so yesterday, Commissioner Lee suggested that the mechanism would be like a temporary restraining order. What's the actual mechanism you're seeking? Or is there, there was also some conversations around the civil rights violation around the First Amendment. So is there a federal avenue?
At this time, we have not advanced a federal cause of action. There are First Amendment interests deeply embedded in this issue. The First Amendment interests of candidates and their supporters are at stake here. No question about it. But right now, we have done exactly what Commissioner Lee suggested. We've asked for a temporary restraining order to simply release the funds on the basis of the court's inherent powers to issue a declaratory judgment.
And I do want to answer the first part of your question, Mike, about plaintiffs, and we can get you the full list, but there are 7 candidates as plaintiffs, House and Senate, and then there are 4 voters who've given qualifying contributions who are also plaintiffs on the suit.
There's actual colors, like you're saying.
Yeah, folks who've given qualifying contributions, we view them as being part of the same agreement that's being made. They give those qualifying contributions with the understanding that that is going to create funding available for candidates. With that not being the case, that agreement is being broken for them in the same way it is for candidates.
So they're equally agreed as the candidates is the argument
To the
I'm a
nature-
lawyer on that question, but
They are affected by having the rug pulled out from under this funding system that they committed to as well. They made their $5 qualifying contributions. It's a token amount, but it's incredibly important symbolic statement of their support and association with that candidate. And it was made on the basis of a system that was promised to the candidates and to the contributors alike. So they all have an interest in the release of the funding.
John, what I'm hearing you say is you will consider filing a lawsuit for fiscal 19 money to be released, but you don't think it's right yet because the legislature's still in session to fix it.
I'm not going to necessarily talk about rightness, and because I don't want to, make a statement that would prejudge anything that might end up going to a court. What we are focused on is the immediate situation. I do think that there is, I know that there are 2 pieces of legislation still pending, and I don't want to burden the court at this time or anyone else with the need to litigate something that might be changed by one of those pieces of legislation in just a few days. So we're focusing on this question right now. Those other questions are certainly on our mind, and we'll reserve all of our rights to pursue other remedies as they become right.
So to be clear on the next part, you think the commission has authority to just release this money? On both sides of this.
The commission is entrusted with the authority to administer the fund. It's a special, dedicated, non-lapsing fund. So those words mean something. Now, the Department of Administrative and Financial Services and the governor have a role to play in the release of funds. It's not a discretionary role as to whether or not the funds will be released. It's a role of transparently accounting for state money, managing cash flow, appropriate bookkeeping, and making sure that the right agency gets the funds, and making sure that the funds are being used for lawful purpose. That's the role of the governor and the Department of Administrative and Financial Services.
So the answer is yes.
The answer is what I just said.
So under the way he's withholding these financial orders or his authorization of these release of these funds, could the governor conceivably pick and choose any of these other special dedicated non-lapsing fund and decide whether he wants to release it or not? I mean, are there other examples of special dedicated non-lapsing funds? Like is there something in public safety or is there something in some other function of state government that is in that same category of funding?
I actually think this is a somewhat unique category. The Ethics Commission's powers here are unique. They've been on the books for 22 years now, and those words were put in the Citizen Initiative a while ago for a specific reason. If you recall at the time, the Ethics Commission before, now I don't know who else will remember this, but before 1996, the Ethics Commission was a little different creature. As of 1996, it became essentially an independent agency with its own fund and its own statutory authority and responsibility to administer that fund. And at that point, the authority of that special, non-lapsing, dedicated fund was with the Ethics Commission, and it always has been. It's not to say that the Ethics Commission doesn't need to work with the state accounting system to manage the dispersal of funds. That's routine and ordinary.
Are there previous examples of this administration having gone ahead and signed these financial orders, or the administrations before them, like where you end up with a similar situation where there was a shortfall or there appeared to be a shortfall?
There have been 3 governors since the elections started in 2000. I don't know, not one of those governors used the elections as a candidate. But all of them have released the funds, including this incumbent governor, have released the funds by financial order as a way to manage the fund. Every one of them have. This is the first time, to our knowledge, at least relying on the information provided by the Ethics Commission, it's the first time that a financial order has not been forthcoming to manage the fund.
I'm sorry to harp on this, but I'm trying to understand your position fully. You think the governor has more of an administrative role, sort of not necessarily a duty to approve financial orders.
It's a non-discretionary function.
So you think he needs to just say yes, basically?
Yes, we do.
Certainly not to make a distinction based on whether he likes the program or not.
We good?
I do paper copies of our press release. I don't have a printout of the actual brief right now, but happy to send that to you.
You guys send it.